Today we are looking at the topic, what is the law on children in conflict with the law? First and foremost is that a child does not have a mind of a criminal mind. In law it is called mens rea. So children find themselves in conflict with the law. And those children are dealt separately. One, any child who is below 18 years will be taken to a children's court. The magistrate who handles this matter is specially trained. That child, the procedure is simple. The child, once arrested, must be taken to a police station in the company of a children officer. Two, once in the police station, that child can only be interrogated in the presence of a parent or in the presence of a children officer. After the child has been interviewed of the alleged issue that has been there, that child will be arraigned before a children's court. Once that child reaches a children's court, the child must be there within 24 hours. At the children's court, the magistrate will do what is called a voir dire test. That is asking this child whether he does questions that are meant to test whether the child understands why the child is in court. If the child is found to be understanding, that child is referred to the children's officer for assessment, whether the child can take plea or not take plea. After that child has been assessed by the children officer, then that child is brought, he or she will be charged. And once that child has been charged, the process is that that child will, at the police station first, that child is normally not held the normal cells. The child must be kept in a child protection unit, a different cell within the police station where children are kept, separate from adults. From court, that child will be remanded in a children's remand home. This is not a prison. They are taken to a remand home. This is a children's place, different from prison. They will be there until their case ends. When the matter comes to court, they have protection measures in court that a child is given. One, the media is covered from covering the faces of the children. The media is barred from reporting the names of the children. The media is barred from publishing their identity in terms of schools and parents. Number two, in court, every time this matter comes to court, the trial, the parent must be present. A teacher must be present, or somebody called an intermediary. Third, as the hearing progresses, the children are protected from being exposed to questions by the advocates that are beyond their age. They give their evidence, and once they find they are being defended, if the court finds out that this child made a mistake, then there is no conviction. The court makes what is called a finding of guilt. Once a finding of guilt has been done, the child can be then committed, one, to a rehabilitation center, two, that's a rehab school, it can be committed to a children's home, or it can be committed to community service order. No child below 18 years will be convicted to go to a prison. Number two, another committal is to a pastoral institution. The prisons have pastoral institutions for children who are above 16, 17 and almost reaching 18. If this child also can be committed to a probation hostel, children cannot go to be committed to prison. That is the new law, the Children's Act Cap 141 of 2022. But there is also another method how children in conflict with the law can be dealt with. That is the principle of diversion. In diversion, the principle is that the children need to go to school. They need not to be in institutions. So this child can be committed to diversion. In diversion, it is a form of mediation, a form of arbitration, where the child meets with the person. For example, if the child stole a banana, the owner of the banana will be called by the children officer, and the parents of the child are there. Then they agree that the parent of the child who stole a banana refunds or pays back the complainant. That is called diversion. The reason why diversion is there is to remove the children from the criminal justice system. Therefore, in principle, as you see here, this is the procedures that the child has got to do as provided for under the law of the Children's Act. The child must be, these matters are normally done very expeditiously. The Children's Act provides that the matters are heard expeditiously. The law now has been changed to allow, to make it mandatory for children in conflict with the law to get pro bono lawyers. And these pro bono lawyers are paid by the judiciary so that their matters are taken very seriously and are expeditiously concluded.